Let's bring it back in studio. No, the festive season is for many people a season of excitement, but unfortunately for others, this excitement can lead to poor judgment that could also influence their decisions about not returning to work in January. So more on this, about the do's and don'ts this season, I'm joined now in studio by Thabang Rapuleng, who's the Director of Employment Practice at Cliff Decker Hofmeyr. Thabang, thank you very much for your time as we wind down the festive season. I imagine you two are doing the same, but it's great to have you on Newsroom Africa.
Thank you for having me, Ian.
And I think it's important, particularly for people like you and me, who, whilst the rest of the country is enjoying the big days, as they say, we have to continue burning the midnight oil, as some say. Take us through what some policies are insofar as what the employer cannot hold you accountable for outside of work. Do such policies even exist?
Yeah. Well, you remain an employee for as long as you still have an employment contract. You remain an employee. The mere fact that you happen to be on leave does not mean you stop being an employee. You are an employee, you are still subject to the policies of the employer insofar as they might be applicable. Well, the policies that will be applicable in the main will be obviously the disciplinary code insofar as there might be off-duty misconduct. We'll talk about under what circumstances can an employer take action against you for off-duty misconduct. But more lately, this one is becoming more apparent. Your social media accounts and the policies that governs how you use the resources of the employer insofar as you've got access to your phone, which you can use to tweet, insofar as you've got an account. Sometimes it's even linked to your employment relationship, because you use it for marketing purposes and so on. That also could contribute towards you now using those channels to commit off-duty misconduct. But there are policies, the disciplinary code in the main, the code of conduct, the code of ethics will still be applicable even though you are now off-duty.
Sure, and so let's talk a bit more about the social media policy. I mean, I see through the time I spend on social media, many people trying to safeguard against, those possible ramifications. So I'm hoping we'll be able to bust some of those myths if they are myths themselves. If I have a social media page, Twitter for argument's sake, and in the bio, I put there a discretion that, these are my own thoughts, RTs are not endorsement, etc., etc. How much can that act as protection against the sanction from my employer?
Well, it does not serve to protect much, because at the end of the day, the test that the employer will conduct is whether or not your conduct, whatever that you have put on social media, has had an adverse effect on the employer, or on the business of the employer, or on the reputation of the employer. If your conduct, what you've said on social media, has an impact on, let's say, the reputation of the employer can still take action against you, notwithstanding the disclaimer that you will have put there to say these are my personal views.
Wow. Okay, and I mean, are there instances perhaps where we found that the link between an employee and the company itself are not easy to distinguish? Say, for instance, I work for this establishment, but I'm not necessarily on camera, and I happen to be in breach of certain things during the festive season. I mean, am I able to argue that whilst I am an employee, making the connection from my actions to the company are not always that clear? I mean, is that a sort of legitimate argument to make in defense?
That's a common argument from the employee's perspective, where the employee will say, but how does this even link up or relate to your business? But it's important to bear in mind that the employer bears the onus of proving. The employer must establish that there has been this connection between what you said on social media and its business or its reputation. So that responsibility lies with the employer to establish, not the employee.
And do you get the sense that there's a conscientization around this? Because the social media phenomenon is relatively new. I understand some people might disagree in some quarters, but I think even companies themselves are still trying to carve out the finer details of their social media policies. From the work that you do, are you getting a sense that, both employees and employers are waking up to this new dynamic?
It's not sufficient. It's not sufficient. I think in most cases it gets triggered when there is now a misconduct in the workplace. Now that you've said something that gained momentum on social media and is causing reputational damage to the employer, that's when the employer tends to wake up to the fact that we need to teach employees on how to behave even when they are using their own personal social media platforms. But I will say there's still more room for improvement in that regard, particularly from the employers, making sure that employees are aware that they could be disciplined for social media misconduct or even off-duty misconduct.
Before we move away from the social media aspect of the conversation, I think there's still a very hot debate around whether or not the posts I put on social media are part of the private or the public space. Because obviously this has implications to whether or not I am able to say certain things on social media. What does the Employment Relations Act suggest about that conversation itself? I mean, does it give any insight to whether or not social media posts are in fact private or public?
No, the Labor Relations Act does not say anything on that, but we've had court decisions which have pronounced on such. And in one of the cases, it was a situation where someone posted a comment on Facebook, and it was a private Facebook page, not open to everyone. But someone took a screen grab of that comment and started to circulate it to other people. And that's how it came out. And they were dismissed, and the court has found that dismissal to be justifiable, because at the end of the day, it has come out, it has leaked, and so far as it has leaked, it has caused reputational damage to the employer, and the employer has a right to take action against you.
Wow. So even if I didn't intend for it to be in the public space, so between you and me, I send you something, and you take a screenshot and post it on your public page, I'll be the one that's sanctioned?
Yes, between you and me, you send me a message, even if it's a WhatsApp message, making, let's say, racist remarks about your boss, and I forward that to other people, you could be disciplined for that.
Wow. Since we're there, how much can people who are sharing the post be sanctioned? Because obviously, part of the reputational damage is also linked to how widespread certain ideas become. You know, if I am found to have also been in the chain of communication, can I be sanctioned even though I'm not the person from which that message originates?
Yeah, provided that you are also the employee of the same employer.
Right.
If you are the employee, we are colleagues, and I happen to be sharing it, then the employer could have a case against me. But again, they left to show me sharing it insofar as I'm bringing it to the attention of the relevant authorities, let's say management, that there cannot be a cause for complaint there. But me sharing it insofar as I'm basically
to relax and not consider it another work day. But I imagine the policies don't change much insofar as what you can and can't do.
Yes, the policies remain in place. The mere fact that you happen now to be having a social gathering of some sort does not suspend the operations of the policies. To some extent, some employers might relax them slightly, but they will not be suspended. Insofar as you commit a misconduct, which is considered to be serious misconduct, the employer is likely going to take action against you. What seems to be common in these kinds of gatherings, you'll find sexual harassment claims, because now we've been consuming some red liquid, and we start making comments and so on, and someone takes offense to it, and the next day they bring it to the attention of management, and they can take action.
And what are some of these policies that are likely to be relaxed then? And where can we push the envelope?
Well, in most cases, you'll find that some workplaces, or most workplaces, they will not allow you to get drunk in the workplace. But you'll find that if it's now our year-end function, you'll see people being tipsy all over, being drunk. The employer is unlikely going to wake up and take action, unless it's a zero tolerance environment for alcohol. But then they will not have brought alcohol in the premises. They're unlikely to take action for that. You'll find that people are likely going to be rowdy, they're likely going to be loud, will be dancing all over. They are unlikely to take action against that. more especially where it is just a staff year-end function. But where you make racist comments, you sexually harass other colleagues and so on, they're likely to take action. That's unlikely to be relaxed.
And before I let you go, I mean, you and I are working during this period, which is largely considered the festive season. I'm wondering whether or not, we're able to have specific rights for having to work whilst most people are away. And the reason why I ask this question is because in most instances, companies are working with skeleton staff, which means each individual worker probably has to have a greater output in order to meet whatever supply there is that typically exists for that establishment. So are there different rights for people working during this period, or you just got the short end of the stick and you must deal with it?
In most cases, we just got the short end of the stick. There will not be different rights. There could be situations where now you're expected to work longer hours, and your policies regulating overtime will kick in. If you do qualify for overtime, then you'll be paid overtime. But you cannot say the mere fact that it's festive season and you're expected to take up something or fill a gap, then you start saying, no, I'm not going to do it. I'll only do it if you pay me more. Someone has tried that kind of thinking.
Right.
They say to the employer, no, employer, you must pay me more for working during this time of the year. And they were dismissed, and the court found that dismissal to be fair.
Sure, okay, all right. We're going to have to leave it there, sadly.
Thank you.
I'm hoping that people will make more informed decisions as we, of course, head deeper into the festive season. That, of course, was Thabang Rapuleng, who's the Director of Employment Practice at Cliff Decker Hofmeyr. Thank you very much for your time.
Thank you.